I am not a crook. I did not have sexual relations with that woman. Read my lips. No new taxes. If you like your health care plan, you can keep it. We did not trade hostages for weapons. We found the weapons of mass destruction. You're not going to get COVID if you have these vaccines. Folks, these are all promises made by presidents of the United States. Our most recent TikTok ruling asks you, as a foundational premise of the opinion, trust the president, trust the executive. They know what they're talking about. But with a line of exaggerations, mistruths, lies to the American public, I think that sets a very weak foundation for the TikTok opinion. Let's jump in. We're here in Washington, D.C., the day before the inauguration. People have an energy and a buzz about themselves right by the White House campus behind us. So TikTok is all about deference, and you might be asking, what's deference? Because it's an important question. Deference is, imagine this, you're taking a vacation and you want to go to a new location, you don't know very much about it. You get in the taxi at the hotel, and as soon as you start taking off, you notice the taxi cab driver's, he's fiddling about with the rate meter. All of a sudden it's going skyrocket high. And then you notice that your hotel that you know is on the east side of town, your taxi driver, he's taking you to the west side of town. He's doing a far detour. And then you look up the rules about how do you get justice for this? How do you take care of this? And the Taxi Fairness Commission says only if the taxi threatens your life or engages in some sort of physical assault is there any sort of claim that you can have. Well, this is sort of like how deference works before federal courts. Deference says that government knows best, and we're going to sort of limit the availability of redress that citizens have for wrongs. And what it means in my mind, as someone who litigates claims in the courts, it seems like an abdication of a judicial duty. Madison helped us set up a government with purposeful checks and balances. Set ambition against ambition. We have the executive, we have the legislative, and we have the judicial, purposefully. And when the executive says something or makes a declaration about national security, it is my perspective that the judiciary has an equal role to be rigorous and to explore that and to act as a check. Now, just recently, the Supreme Court decided the Loper case. And in that case, the court examined a long-standing doctrine called Chevron deference. I won't bore you with all the details of that, but it was examining when someone challenges an administrative agency like the EPA or the FEC in a ruling or a holding that they make. The Chevron deference said, we're going to give a little bit of a benefit of the doubt to an agency. We think that these folks are experts. We're going to place the thumb of justice ever so slightly on the scale in favor of government authority. And this created real problems for individuals trying to bring litigation against the federal government, because minor to intermediate abuses became very difficult for folks to be able to demonstrate. Only the most egregious examples of abuse, violations of civil rights, constitutional rights, and the like would provide redress for individuals. So the Supreme Court finally overturned Chevron deference in the Loper case. And in other areas of the law, it's probably an area of development that we're going to be able to see, because as I noted earlier, it's sort of judges being hands-off about government authority, which I think is the exact wrong position that they should take. So why is deference bad? I think deference sends a clear signal to an administrative agency, to the executive branch, that when it exaggerates, when it fabricates a claim, that there's going to be very little judicial recourse for it. And that's only an incentive for the executive or other units of government to act badly. It's also going to distort legal reasoning. If justice is our aim, we want accurate policies, accurate evidence, accurate positions to be part of the record, so that when we formulate a rule purportedly to bring justice, that is based on solid information. All of this is destroyed when you have judicial deference to executive action or administrative action. So let's pause for a minute and think about, how does judicial deference matter if you're a liberal or if you're a conservative, or maybe you're somewhere in the middle in America. If you're a liberal, you should hate judicial deference if you dislike the case Trump v. Hawaii. Now, if you're not immediately familiar with that, that's when the first Trump administration enacted a ban on travel from Muslim-majority countries, and a variety of nonprofit, civil rights, constitutional groups challenged that and said that it damaged these sorts of core freedoms. And this case, of course, went quickly up to the Supreme Court, and the Supreme Court deferred to the executive's determinations very quickly about national security implications. And it said it's not our role as a judiciary to second guess policy preferences and decisions of the executive branch. And so advocates of inclusivity, religious freedom, other constitutional issues that were at bay in the case, this was a loss for them because there was no meaningful review of the issues. There was just a nod and a rubber stamp to the executive. Now, if you're a conservative, this matters to you as well, because you probably dislike the result in Arizona versus U.S. Now, that was a case during the Obama administration where Arizona felt that the Obama administration was not doing enough to secure our borders, that illegal aliens were passing into our nation, and that Arizona as a state had a duty in our sort of dual federalist system to be able to step in and fill in the holes. And the Obama administration challenged that. And again, the court took a familiar stance and said, look, if it's in the purview of the national security and the executive branch says it's acting in that way, we're not going to instill our judgment over that of the executive branch. We're going to trust that what they say is true. And so that damaged sort of a system of dual federalism and what conservatives were concerned about when it comes to issues of immigration control, border control. And if you're just about anyone, you probably don't like the result from Korematsu. That's, of course, the case that upheld the internment of Japanese individuals during World War II. Now, we have the luxury now of having been able to see evidence and reports that were available at the time, and we know that there was no credible evidence suggesting that some wide swath of Japanese Americans were going to rise up in some sort of rebellion or damage the United States. In fact, we know that there was an actual official report that discredited the Japanese threat. It was before the president's very desk. And yet this case went to the Supreme Court, and folks, here's why that rule stood. They said, if the executive tells us, if you like your health care plan, you can keep it, read my lips, no new taxes, we're going to believe you. And we have a string of abuses throughout American history. And it's decades, sometimes a century later, when we learn out what the real truth is. I don't think that's any sensible way to carry out justice in America. And that same problem rears its head in the TikTok case. Okay, so before we jump into the exact pinpoint holding of TikTok, I want to just ask this question or answer this question. What would a no deference or low deference sort of approach look like? It'd be like if you or I went into court and we want to make a claim. It's an evidence-based approach. We have a certain burden of proof that's put on us to be able to make a showing that our claims are indeed true and correct, and that justice requires the entry of judgment in our favor. We can't just point to government newspaper releases. We can't just say, Ben Barr's a terrific expert and quite a wise man, and judgment should be entered in his favor. We can't just shrug. And this is the level of redress that we should expect judges apply to actions of the executive or of the legislative branch. Now, if it involves key constitutional liberties, we should see an even higher scrutiny. We should see government asking that there's some very dramatic, compelling interest that is at hand, and that whatever means is used to achieve it is a very narrow and as gentle as possible means that doesn't suppress too much speech or too much religious freedom or whatever the particular liberty interest might be. That's a really important foundation to have. So in the TikTok case, it's Justice Gorsuch who, interestingly, files a concurring opinion. And it's a very interesting read because he's the justice who gets closest to the real issues that are at bay here. And they're the cases I discussed in our deep dive in the first video where we walked around New York City to explore these issues. And that is, he touches on the Abrams case. He touches on the writings of Justice Holmes and Brandeis, who, as you'll recall, were influential justices during those series of World War I protest, free speech, national security cases. And he really tries to delve in there and tries to make a meaningful analysis. But he also notes Congress only gave them so much time to decide this. It was an exceedingly expedited case. They had to decide the issue in a short amount of time, and he brings some humility about that, which I think is positive. So the interesting line that Justice Gorsuch uses, and I think it's an appropriate analogical difference between earlier cases and TikTok, and I give him the honorable mention, at least out of all of the justices, that he comes close to scratching the correct constitutional standards. He says speaking in favor and with a foreign adversary is one thing, but allowing a foreign adversary to spy on Americans is quite another, and that's why he then defers to the judgment of the executive branch. That's a good analogical difference. I'm not sure it carries the day, but I'm glad that he at least struggled with the cases. What the Supreme Court should have done in the TikTok ruling was to dig down into some of our nation's treasured precedent that do define what is the correct standard you apply when First Amendment rights about national security concerns. And we can go back to 1919. We can look at what Justice Holmes described in his Schenck opinion in the clear and present danger test. Now, 1919 is early. We have to catch it up and build it into modern free speech jurisprudence, but we need an analytical framework, and the fact that it was lacking tells us something about the TikTok opinion. There's other precedent the court could draw from, too. We could go to Pentagon Papers, and we have to work on borrowing from those 6 different concurring opinions, but we can at least pull out of Pentagon Papers that the test there seems to be if there is a national security interest that's in tension with free speech, that the threat must be direct, it must be immediate, and the harms conceived must be concrete, not speculative. Now, that's a really important line, and if we think about Pentagon Papers as being a persuasive opinion that should have some effect here, it's sad that it was overlooked by the Supreme Court, because most of the so-called evidence involved in the TikTok ban is really about what newspapers have reported, because the government never relied on its classified and top secret sort of findings in the TikTok case. It said, well, you can look to the public record. We already know exactly what China's doing. And in all of this surveillance that it's doing to the American people, we can imagine that it could target U.S. intelligence personnel, and that it might blackmail, say, people involved in an affair. It might blackmail or extort a person who has a drug habit that they don't want disclosed. But there's no hard evidence, the sort of direct and immediate evidence that Pentagon Papers calls for, or if we go back to Schenck, looking at the degree and the proximity of that danger to the national interest. Those are really important analogical models that should have been present in the court's reasoning, but instead what we get is a government has said that this is a real serious concern. We could imagine bad things are going to happen, so we rubber stamp that move. Okay, so what's important to do is then to consider what was the evidence, at least what were the newspaper headlines that is classified as evidence that was brought before the court. And so one line of this was that China would be engaging in extensive and year-long efforts to accumulate structured data sets about U.S. persons to support intelligence and counterintelligence operations. Another line of reasoning and supposed evidence from the public record was that a designated foreign adversary could leverage its control over ByteDance to capture personal data of TikTok users. But there's never any deep dive into any of these stories, any of the public record that was supporting this. There's just a rubber stamp of, well, we can imagine China's an adversarial country. We haven't had good relations with them. They're going to do bad things, while we're entirely missing the sort of this fit and interest analysis that the Supreme Court was supposed to do. And at least Justice Gorsuch gets an honorable mention for trying to do that. All right, so we're just sort of wrapping up and thinking about this case here. Now, as it turns out, we're one day before the inauguration. It looks like President Trump is probably going to bring a political solution to this problem. TikTok might be live today. I've seen some reports indicating this. It probably will be live very soon. And so in that sense, the executive is stepping into its role to try to solve this situation. But really what I would have wished occurred here was that the judicial branch would have engaged with a little more scrutiny, a little more rigor, examining what these security claims were that were before the court. I think all of America, whether you're on the left and a liberal and you hate the Trump's travel ban, or you're a conservative and you hated the Supreme Court's opinion in the Arizona immigration case, I think everybody loses by not having that sort of rigorous introspection and analysis of the evidence. It's what you would face in court, it's what I would face in court, and the government should be no different. So we may see a political solution. The other problem with that, as John Adams said, is America is an empire of laws and not of men. We shouldn't have to hold out and wait for a courageous leader or someone taking a stance to change the law when the judiciary was empowered to do so. We can also just hope that in the future that the Supreme Court, maybe with more time in the right case, can revisit sort of the deference that it's going to apply in these kind of cases, and that it's going to give more weight to First Amendment interests and at least allow for a deeper dive and hold the government to better account by demanding a showing of this type of evidence. So we're going to wrap up today here, a very cold, brisk, windy DC, right at the Department of Justice. What a perfect place to end. And we'll be shooting a few more videos in DC before we go on our next travels. And we're going to capture some fun and contentious topics like money in politics and ethical concerns with Congress and free speech interests that abound there. Stay tuned. We'll have a lot more fun information to come. As we're closing this down, I want to direct my audience's attention to what Justice Holmes wrote in his dissent in Abrams, because I think it speaks poignantly about the dire need to preserve free speech rights during a time of national emergency and for the right of dissent to survive even in a time of war. He said, "But when men have realized that time has upset many fighting faiths, they may come to believe even more than they believe the very foundations of their own conduct, that the ultimate good desired is better reached by a free trade in ideas, that the best test of truth is the power of the thought to get itself accepted in the competition of the market, and that truth is the only ground upon which their wishes safely can be carried out." That, at any rate, is the theory of our Constitution. It is an experiment, as all life is an experiment. Every year, if not every day, we have to wager our salvation upon some prophecy based on imperfect knowledge. While that experiment is part of our system, I think that we should be eternally vigilant against attempts to check the expression of opinions that we loathe and believe to be fraught with death, unless they so imminently threaten immediate interference with the lawful and pressing purposes of the law that an immediate check is required to save the country. That's a pretty high bar Justice Holmes would set, and it's one that I hope the Supreme Court eventually enforces.
It's a party in the U.S. baby. You got that right.
Key fact, South Detroit does not exist.
Sorry.
Everything's 50% off on the table, guys. No line, no wait. Take a look. Everything's 50% off, guys. When I pay more, you can save more. Trump is back, baby. Come on up.
Trump is back and the markets are open.